Adaklu, and he now is one of the leaders in Parliament. Today, the vetting of the 7 individuals I mentioned will begin. Professor Bafo Ajibanduya is joining us on the phone line now. He's a former UN Senior Governance Advisor, and also Mr. Samuel Abing, he's Executive Director, Parliamentary Network Africa. Gentlemen, good morning. Thank you very much for your time.
Good morning, and thanks for having me.
Great, and belated Happy Father's Day to both of you.
Thank you so much, and I wish you the same. I believe you're a father too.
Yes, Prof, I am indeed.
Great.
Yes.
I know you're a very good father.
Thank you, sir, Prof. Thank you very much. Prof, let me begin this conversation with you. Today we're going to have our Parliament vet these nominees, and hopefully if they go through and they satisfy the prerequisites, they will be approved. This is at the time when the Chief Justice is on suspension. There's an acting Chief Justice, and people are looking at the judiciary, particularly the Apex Court, with a certain kind of perception in their minds. What do you advise the parliamentarians who will be sitting around the table to vet these nominees to do?
Oh, goodness. Well, they have a parliamentary duty to perform whenever the president submits a list of nominations, as President Mahama has done. They have to review their applications, interview them, what you call the vetting, and based on their findings, if they are satisfied with their qualification, they simply have to approve the nomination for the president to eventually appoint those individuals. But knowing too well what has been happening in the past few months or perhaps years, there have been a lot of public comment about the judiciary, especially the Apex Court. And you did mention that currently the Chief Justice is under suspension. There's an acting Chief Justice.
That's right.
So certainly one can say that there seems to be some instability in the judicial sector, but thankfully it's functioning very well, even with the suspension and the acting role being played by the current Chief Justice. Now, having said that, I think one of the concerns of most people, including myself earlier, has been the question of how many Supreme Court justices should we have. I understand these 7 nominations, if all approved by Parliament, will bring the number to about 20 or 21.
21, that is.
Normally, we've been thinking that, and just thinking of most people, that maybe around 14 or 15 is the best. But that is our thinking. It becomes wishful thinking whenever a president decides to do otherwise. And the president has done no wrong here. He's acting within the Constitution, because the Constitution does not place any limit on the number of justices in the Supreme Court.
Right.
And that in itself is worrying, because as you know, you can easily envision a situation where, because of the kinds of politics that we have in the country, we can even have 30 Supreme Court justices. So my thinking is that perhaps with the Constitutional Review Committee still ongoing, this could be one of the issues they may want to take a close look at.
I see. So, let me bring you in. You've worked from Parliament before. The Parliament of the Republic of Ghana, particularly the Appointments Committee, have been fingered in many instances to be a rubber stamp or a conveyor belt of a sort, where nominees that come before them, whether they answered the questions that were satisfactory or the answers were not satisfactory, they still go through anyway. What is your view on that perception?
Well, Johnny, it's a perception that over the years, Parliament itself has not done itself a lot of good in dispelling. And sometimes when you allow some of these public perceptions to fester, it almost becomes, factual. However, we also know that, and because we are discussing members of the judiciary who need to be given prior approval by Parliament,
right?
I intend to cite this example. We also know that Parliament in the 8th Parliament were presented with a couple of nominees for the Supreme Court.
That's right.
Eventually, this quote and unquote conveyor belt scenario did not play out because the eventual approvals were not given. Parliament could not conclude on that subject matter. We know what went on, at the time, and so for me, it gives an indication of the need for Parliament to play its role. Of course, we are not saying that because I'm not sure anybody is suggesting that Parliament must necessarily be looking for ways to disqualify people, even if there is no real merit for disqualifying them. I think what the public is looking out for and why this perception seems to be out there is that most often than not, it appears that when you watch the proceedings, on the floor of Parliament, you watch how members of Parliament go about it, you watch proceedings during the committee sittings, you come to think that, it's more of the politics of the day who scores political points rather than, the processes of making sure that we have people who are entrusted with the responsibility of taking charge of our country in various facets, whether at ministerial level or at the judiciary. And it's an expectation that just as this 9th Parliament vetting process, some of it has been rigorous. I mean, we know the challenges that came with some of the sitting days and some of the very despicable situations that happened. But we expect that the new standard of ensuring that members who are nominated for various positions are taken through some form of rigor, gets maintained without the excesses of some of the things that we do not want to see from Parliament coming up. And I think most often judicial vettings have been relatively better, in my opinion, than vetting of executive members to the executive branch.
Prof, I bring you in again. There's also another perception that depending on which administration nominates a judge, the judge tilts in favor of that administration. Many judges have tried to dispel that perception, but it seems to have stuck, as Sami said, because the judiciary may not have done what they ought to have done publicly to purge itself of that perception. What do you say to that, sir?
Well, first of all, let's be clear here. In a democratic system, especially when you have the political duopoly, two political parties dominating the system, as we have here, you are bound to look at presidential appointments with suspicion. That is to say, the opposition normally will look at the presidential decisions and appointments with suspicion. I don't know if it's any more useful to go to the United States, for example, but for the sake of this discussion, we know that in the U.S., when a Republican president appoints or nominates justices to the court, they do with a certain sense of, orientation, because they don't want to put someone known to hold views that are opposite to the doctrine or the beliefs of that party. So it's very true that presidents do select and appoint people who they think will endorse endorse them when they make decisions or when cases come to the court. In fact, we have seen that many times. We remember recently when Biden appointed the lady, the first black lady to go to the court. If you follow the discussions in America, clearly they took sides. The Republicans didn't want it. So they said she was too liberal. She supports abortion, blah, blah, blah. And then, of course, finally, she was approved. And it's been the case consistently over the years in the U.S. So here, I'm not surprised that having a duopoly as we have, political duopoly, we're going to have that all the time. In fact, that is why at least one country that we all know has cleverly avoided that situation by taking the appointments away from the executive to a judicial committee or commission. I'm talking about Kenya, where the president does not nominate. The judicial sector has its own judicial council, which, when there's a vacancy, will advertise publicly, qualify people who apply, you do the screening, select top 2 or so, and submit to Parliament. Once Parliament approves, then it goes to the President to sign. And that seems to have mitigated this serious concern that we have in duopolistic political systems. So if we are concerned about that, and truly, unless the Constitution is amended, we can envision a situation where we're going to have about 30, 40 justices. Because if we go on this tangent, that these people are appointed by this party, say NPP or NDC, with they are all NPP hatchets, and therefore when we come, we're also going to appoint X number to balance it, as the argument has been. Then, suppose there's a change of government next time, and they also come because you can't fire justices, so we're also going to appoint a set of justices to balance. Man, we're going to find ourselves in a serious mess. So personally, looking at all this, and I think the American example is not the best, we should begin to rethink how we do this. In fact, not only the judiciary, I will even advocate similar changes for the appointments of the independent constitutional bodies, the EC and all, because the EC has demonstrated this kind of dilemma for us, the firing of Charlotte Osei and the threats to fire the incumbent one. So I think we need to think seriously to create some sense of stability in the way these key institutions function.
Sammy, you look at the conversations around the capping of the number of judges at the Supreme Court, and then some others also argue that their functions or the functions of the apex court is perhaps different from the situation in the United States, South Africa, and so many other places. Because in the case of our Supreme Court, they have original jurisdiction, which is to interpret the Constitution. They have appellate jurisdiction and some 3 others. Does that argument hold in terms of to cap or not to cap the numbers at the Supreme Court?
Tony, I like to look at this situation first from the point of what our current constitutional arrangement, allows.
Right.
And that's why, of course, Prof, eloquently indicated how, His Excellency the President or any president in the past may not necessarily have committed any breach of the Constitution by nominating and nominating. And so at the moment, we have a system that does not, prescribe capping. And we have an opportunity to be able to also, change our system. But fortunately, the current system that we run has been run in this country for over 3 decades. What that means is that we've been able to experiment it. We've had justices of the Supreme Court, retired and in active service, who are able to sit around the table in this current arrangement of trying to amend our Constitution or constitutional review process to advise on what the reality truly is at their level, because he who feels it knows it. So having experienced it, having gone through the process, having led at the apex court, having sat on the bench over the period, some of them will be able to provide a better arrangement that will suit our unique Ghanaian system.
Right.
That having been said, I think that anybody who truly is thinking about these things holistically would know that to run a system where there is absolutely no cap and people can go, or nominators or the president can go to whichever length with the numbers, is not a very good arrangement, because it has various implications. It has cost implications.
Right.
It has the public perception implications. It has the stability of the judiciary implications. And by cost implications, we are not even talking about cost while they are serving as justices of the Supreme Court. We are talking also about cost when it comes to after they had retired, and issues around whether the Supreme Court meets all of those numbers, and issues around the administrative people who are supposed to serve under them and work with them and all of that. We need to be careful about the bloating of the numbers or taking the numbers to extents that are not manageable. But in doing so, like I said from the beginning, we also need to be minded about what the last 3 decades and more have taught us, so that in deciding on whether to cap or not to cap, and even at capping, what numbers to cap it at, because of the various responsibilities that the Supreme Court has, it will be informed by real facts, real data, real experiences of people who have lived these roles over the years.
Yeah. Prof, now I come to you. We have seen the Parliament of the Republic of Ghana vet ministers. Some have called it marathon vetting because some have even crossed the first day and gone into the second day. Some have done 6 hours and all of that. Would you be surprised if you see that in the selection of these judges, particularly because of the public interest at this time in the life of the judiciary?
Well, if any of them will have to travel beyond 5 hours or 6 hours, as you are saying, then I hope there's a substantive matters to be addressed. Otherwise, it will make no sense to keep somebody that long. Moreover, there's overwhelming majority in Parliament supporting the president. That's the president's party is an overwhelming majority. Right. So if they want to really have their way, they will have their way. So I guess my response is that if there are substantive matters that need to be probed, sure, we can even go for 10 hours. But not for the sake of politics or showmanship or anything of the sort. You see, because these people nominated have been on the bench for I don't know how many years. They are all known individuals in terms of their performance in the court over the years. But of course, there could be something that you and I may not know about the individual. So if this is the time the parliamentarians will fish that out, that's a different story. Otherwise, there will be no sense in going that long. But I think what is important here, the argument that perhaps some of us are making should not come to the floor during the interrogations or the vetting. That is to say, why would the president appoint 7? It's a useless argument because, as I said earlier, he has the power to do that, and he has done it.
Right.
You can only go and challenge the constitution, not the president. So if they use that kind of argument to delay the vetting, for me, that would be a waste of time. Then what else? All the issues I've raised about. I think what we'll have to begin to look at, and I think my colleague on the other line alluded to that, and I think I said it earlier too.
Yes.
I think we need to look at our system creatively and innovatively. Sure. We've been around with this constitution for 32 years plus. We know the challenges that we have. You see, in a pluralistic democratic system, that is, having more than 2, some of these issues will not arise. But in our system, in our political system here, they are bound to arise. Look, because somehow we tend to politicize everything in what we do nationally. And that is a problem that I don't know how we solve it. So let's begin to look at systems that can be devised to mitigate the negative impact of such a system on what we do as a nation. And for me, the judiciary is perhaps one area. And I think, I don't know whether the judges themselves can think about the system, because in fact, the Constitution gives them independence. And I think with that independence, they can also do a critical review of their performance over the past 32 years to come out, to tell us the problem. Look, this thing about so many cases, we have to create more judges. I think it's an argument that I don't buy. Because why can't we, again, make changes? If the court has the original jurisdiction on constitutional matters, which is true, can't the Supreme Court relegate some of these duties to the lower courts so that the Supreme Court can just become the court of appeal when, these things, people are not satisfied at the lower levels. So I think we just have to think creatively. Because if it's a matter of cases, and therefore we should create judges. In fact, I've even heard somebody suggesting that we should open a part of the Supreme Court in Kumasi or the North or something like that. Hey, I think we just have to find out. Because you know what? The Supreme Court justices, like other high-level appointees, they retire on their full emoluments.
Right.
So even if you look at the economic side of running the judiciary,
right,
and if you look at the fact that the justices enjoy certain privileges that the executive does, including free travels in a number of years and free vehicles and free guardian boys and all, it's making our budget top heavy with servicing our public personnel. And that's why I don't have enough left for development. So I think the economic side of this must also be examined, so that we do not simply say, because the work overload is so much, let's keep on appointing more and more and more. So I think all these are issues that might be examined carefully for us to think how we can maintain a decent number of justices without needlessly creating Supreme Court offices around the country and appointing more.
So my final question to you is this. Yesterday, when we put out the flyer that we're going to have this conversation, a communication studies student came asking, I hope they don't go asking the judges, what do you intend to do when you get to the Supreme Court? Because you claim that they have heard it too many times at the vetting table. What do you say to the thoughts that this young student expressed yesterday?
Well, Johnny, at the level of the vetting appointment committee processes, it is important that we look at the experiences that we have had, the situation that has played out holistically. Look, over the last couple of years, we've had a number of appointment committee sittings that have vetted justices nominated for the Supreme Court. I would need us to carefully look at how the conversations have gone at those vettings. They're quite different from how the conversations go during the executive branch, nominees when they are being vetted. Why? Because no matter what is happening in our country, what has happened in our country in the past, we still have some reverence for our judiciary and the place that it holds in our governance architecture, for which reason members of parliament know that these things are not, or exercises are not ones that must be taken lightly, and they must be approached with the seriousness that it deserves. And so I expect that it would be approached with the seriousness that it deserves, especially also now that Parliament is still applying the rules as pertains in its current standing audit for this vet. What that will mean is that the panel will be made up of, the vetting panel will be made up of the core members of the appointment committee, of which a good number of them, especially those in leadership, are all lawyers and understand the implications of some of these appointments and where we are as a country now, so far as the judiciary is concerned, and the need for Parliament as an important institution to use the platform and opportunity it has got to send a very good signal, to the people of Ghana. And then, of course, that core group will be joined in by members of the Judiciary Committee of Parliament, who are also made of people who are engaged and interacting with the judiciary on a regular basis, so far as parliamentary oversight and Parliament's responsibilities are concerned. And so I'm expecting a panel that really should be worth its salt, for which reason should be asking the kinds of questions that should be bringing out the best in the individuals that we are nominating, especially also when the individuals that have been nominated are people of, they are not men and women of straw. These are top judges, at the level of an appeals court, I think almost all of them, if not all, who are being, quote unquote, promoted to the Supreme Court. And so these are people of substance. And when you have the opportunity to engage with people of substance in the full glare of the public, because this is going to be telecast live, you've got to attach some level of seriousness to it. And that is my expectation of the Parliament of Ghana. So I really do not expect that this will be similar to what we see when it's vetting time for members of the executive, ministerial nominees. I think that the standards should be much higher. But well, a parliament can sometimes disappoint. I hope they do not this time around.
Samuel Bing of the Parliamentary Network Africa, we're grateful that you joined us this morning. Prof, you have the closing thoughts. What do you leave us with, Prof?
Well, in a way, I associate myself with my colleague in terms of the behavior expected of the parliamentarians. I think there should be no showboating and those kind of things, because truly, these people, the 7 nominees, certainly, they've accomplished jurists. Unless, that's what I said earlier, that unless there is something about any of them that we do not know, I don't think they should use politics to delay it and to ask questions that are not relevant in this case. So my point is simple. I think we should go ahead, get them installed, but beyond that, Parliament itself should look at championing a change in the appointments of these independent institutions, because you cannot have effective checks and balances in a democratic society such as we are seeking to build if these institutions lose their independence, either by way of how appointments are made or by way of how Chief Justice will just sell himself or herself to the executive and all kinds of things. But I think the appointments are made neutrally, as I've suggested earlier. Then hopefully we cannot trust that the judiciary will have the trust of the citizens, and their work will be highly revered as it should be.
Prof, I thank you very much indeed for your time. That's Professor Bafo Adjumandua, former UN Senior Governance Advisor. We're grateful to you, Prof.
Thank you.
That's our conversation here, and your thoughts and comments are always welcome and invited. You can join us on our Facebook page at 3FM927.